There are moments in life that split everything in two: before and after. For me, that moment came on a gray Tuesday morning in a small law office that smelled like old paper and cheap coffee. I was sitting in a wooden chair that was too hard for how long I'd been waiting. My hands were folded in my lap. My eyes were dry, not because I wasn't hurting, but because I had already cried everything out the night before, alone in my car, in the parking lot of the very hospital where my grandmother had taken her last breath. I was 31 years old. I had just lost the only person in this world who had ever truly loved me without conditions, without an agenda, without asking for anything in return. And I was about to find out that even in death, she couldn't protect me from the people who were supposed to be family. My name is Elise, and this is the story of how my Uncle Gerald stole everything my grandmother left me, and how a quiet, soft-spoken woman named Mrs. Patricia Osei, sitting behind a small desk with a recorder she never turned off, gave me back everything he took. But I'm getting ahead of myself. Let me take you back to the beginning. Because to understand what happened in that law office, you need to understand where I came from. You need to understand who my grandmother was. And you need to understand what kind of man my Uncle Gerald really was. Beneath the expensive suits and the easy smile and the reputation he'd spent 40 years carefully building in our small town. You need to understand the full picture, because the truth, when it finally came out, was bigger than anything I could have imagined sitting in that hard wooden chair on that gray Tuesday morning. My grandmother's name was Dorothy Mae Collins. Everyone called her Dot. She was 78 years old when she passed, and up until the last 6 months of her life, she had the energy of a woman 20 years younger. She gardened, she cooked. She drove herself to church every Sunday in the same white sedan she'd owned for 15 years. She read 2 books a week. She wrote letters by hand, actual handwritten letters, to people she loved, and she kept every letter anyone ever sent her in a shoebox under her bed. She was not a wealthy woman by the world's standards, but she owned something that, in our town, was worth more than money to the people who wanted it. She owned the house. Not just any house. Dot's house sat on 4 acres of land at the edge of town, the kind of land that developers had been quietly circling for years, like vultures waiting for the right moment. The house itself was modest: 3 bedrooms, a wide porch, a backyard with a pear tree that Grandma had planted with her own hands the year she got married. But the land? The land was worth somewhere between $600,000 and $800,000 depending on who you asked. And as the town grew and the new shopping development crept closer every year, that number kept going up. Everyone in the family knew the land was valuable, and everyone in the family knew that Grandma had only one living child left, my Uncle Gerald. My mother, Linda, had been Gerald's younger sister. She died in a car accident when I was 9 years old. After that, Grandma raised me. She took me in without a single hesitation, without a single complaint, and gave me the kind of childhood I would not have had otherwise. She taught me to cook. She helped me with homework. She drove me to school every morning and was always standing at the door when the bus dropped me off in the afternoon. She was my mother. In every way that mattered, she was my mother. And Gerald knew that. He had watched it happen for 22 years. He'd watched Dot pour herself into raising me. He'd watched her spend her savings on my school fees, my college applications, my first semester of university before I got a scholarship. He had watched all of it from a comfortable distance, coming to visit a few times a year, always with his wide smile and his loud voice, always bringing a bottle of wine or a fancy dessert from the bakery in the city, gestures that were designed to look generous without costing him anything real. He was charming. I'll give him that. He was the kind of man who could walk into a room and make everyone feel like he was their best friend. Grandma loved him. Of course she did. He was her son. But even she, with all her wisdom and all her gentleness, had a small blind spot when it came to Gerald. She saw what she wanted to see. I saw what was actually there. And what was actually there was a man who had been watching that land his entire adult life, doing the math and waiting. About 2 years before she passed, Grandma had a health scare. Nothing catastrophic at the time, a minor stroke that left her shaken, but mostly recovered. But it changed something in her. It made her practical in a way she hadn't been before. One afternoon, about 3 weeks after she came home from the hospital, she called me into the kitchen. She poured 2 cups of tea, sat down across from me at the table, and folded her hands the way she always did when she was about to say something serious. She looked at me for a long moment before she spoke. "Elise," she said, "I need you to know something, and I need you to remember it, no matter what happens after I'm gone." I tried to tell her not to talk like that. She stopped me with a look. "I'm not being morbid," she said. "I'm being responsible. Now listen." She told me that she had updated her will. She told me that she had worked with a proper estate attorney, a woman she had found through her church, and that everything had been documented carefully and legally. She told me that the house, the land, and her savings account were all designated to go to me. She said she had left Gerald a generous sum in a separate account, enough to be meaningful, because he was her son and she loved him. But the property, the main property, was mine. "This was your mother's home too," she said to me. "Your mother grew up in that house, and you grew up in that house. This is your inheritance, your foundation." She reached across the table and put her hand over mine. "I've made sure it's done right," she said. "The lawyer is thorough. She keeps records of everything. I trust her completely." I told her I trusted her too. I told her I didn't need to know the details, that I trusted whatever she decided. She shook her head gently at that. "That's sweet," she said. "But ignorance isn't protection, baby. You need to know this exists, so that if anyone ever tells you different, if anyone ever tries to tell you that I said something I didn't say, you know the truth." At the time, I thought she was just being cautious. The stroke had made her think about worst-case scenarios. I didn't think she was warning me about anyone specific. Later, I would understand that she was. Life went on. Grandma recovered well from the stroke and had a good 1.5 years after that. Gerald visited more frequently during that period. I noticed it but didn't read too much into it. He was attentive, helpful, bringing groceries, offering to handle the utility bills, taking Dot to her doctor's appointments when I couldn't get away from work. He was present in a way he had never been before. I told myself it was because the stroke had scared him, that he was stepping up because he realized how little time any of us might have. That is not why he was there. 6 months before Grandma passed, her health declined sharply. The doctors found complications in her heart. She was in and out of the hospital, then home with assisted care, then back in the hospital. Gerald inserted himself completely during those final months. He handled correspondence. He spoke to doctors on the family's behalf. He managed the household accounts while Dot was too weak to do it herself. He positioned himself as the devoted son, the one who was there, the one who was handling everything. And because I was working 2 jobs to keep my rent paid and driving 40 minutes each way to visit Grandma every single day, I didn't see what was happening right in front of me until it was almost too late. Almost. During one of my visits in those final weeks, Grandma had a lucid afternoon. She was weak, much weaker than she'd ever been, but her mind was sharp that day. She held my hand and looked at me with those clear brown eyes and said, "Elise, Gerald has been asking me about the will." I went still. "He's been asking me to make changes," she said. Her voice was quiet but steady. "He says he's only trying to protect the family. He says the property should stay in the family name, not go to you because you're not blood." My chest tightened so hard I could barely breathe. "I'm not blood?" I whispered. She squeezed my hand. "You are my blood. Don't let anyone tell you different." She paused. "I didn't change anything. I want you to know that." I told him no, but he's been talking to people I don't know. He brought a man here last week while you were at work. Called him a legal consultant. She looked at me with eyes that held something I had never seen there before. Fear. I told the man nothing, she said. I signed nothing. But Elise, she paused. After I'm gone, be careful. Be very careful. 4 weeks later, she was gone. And 3 days after her funeral, Gerald called me and told me there was going to be a will reading. The attorney's office was not the office of the woman Grandma had told me about 2 years earlier. I noticed that immediately. I had always assumed the will reading would happen at the offices of Grandma's estate attorney, the woman from her church, the one she had described as thorough, the one she had trusted completely. Her name was Patricia Osei, and I had met her briefly once, at a church event a few years back. A quiet, careful woman with reading glasses and kind eyes. But Gerald had arranged the will reading at a different office entirely, a firm I had never heard of on the other side of town, with a young attorney named Mr. Harlan, who had a firm handshake and absolutely no warmth behind his eyes. I walked in and sat down. Gerald was already there, in a dark jacket, looking perfectly composed. His wife, Sandra, sat beside him. They both nodded at me when I entered, and Sandra gave me a small, tight smile that I had never trusted even in good times. There were papers on the table. Mr. Harlan cleared his throat and explained that he was representing the estate of Dorothy May Collins. He said there was a will and that he would be reading it today. I asked quietly why we weren't at Mrs. Osei's office. Gerald explained smoothly that Grandma had updated her will in the final months, that she had decided to work with a new attorney who had a better understanding of estate law, particularly around property transfers. He said all of this calmly, as if it were the most natural thing in the world. My hands went cold. Mr. Harlan began to read. He outlined the details with the practiced efficiency of someone who had done this many times before. He mentioned a small savings bequest. Then he got to the property. The house, the 4 acres, and the primary estate, all of it, was designated to Gerald Collins. To me, there was a single line, a sum of $11,000, described in the document as a gesture of gratitude for years of companionship. Companionship. 22 years of being raised by this woman. 22 years of being her granddaughter in every way that mattered. $11,000 and the word companionship. I sat completely still. I felt the room tilt slightly, the way it does when something is so wrong that your body registers it before your mind fully processes the words. Gerald cleared his throat. "Elise," he said in the measured tone of a man who has practiced this speech. "I know this might be difficult, but Mom gave this a lot of thought in her final months. She wanted the family property to stay within bloodlines. That was her decision, and we have to respect it." I turned and looked at him. He held my gaze with perfect steadiness, practiced, prepared. I said nothing, not because I had nothing to say, but because something happened inside me in that moment. Something clicked into place. Grandma had warned me. She had looked me in the eyes and warned me. She had told me she had a thorough attorney who kept records of everything. Gerald had brought a new document, a new will, from a new attorney. And somewhere out there, Patricia Osei still had the original. I walked out of that office with the $11,000 ringing in my ears and a single thought pounding through my head. Find Mrs. Osei. I drove home that day in a fog. My hands were on the wheel, but my mind was somewhere else entirely, moving through everything Grandma had said, every warning, every careful word she had chosen. She had not been vague. She had been specific. She had told me the attorney was thorough. She had told me to be careful after she was gone. She had told me the will was done right. The question was whether done right still existed somewhere, or whether Gerald had found a way to erase it. The first thing I did when I got home was go through every piece of paper I had from Grandma. I had a small box of documents she had given me over the years: insurance papers, old letters, a copy of my mother's birth certificate, a savings account statement from years ago. I went through it all methodically, looking for anything connected to Patricia Osei. At the very bottom of the box, I found a small card, the kind that attorneys hand out at church events: plain white, clean black lettering. Patricia A. Osei, estate attorney, serving families with care. There was a phone number and an address. I held that card in my hands for a long moment. Then I picked up my phone. She answered on the third ring. When I told her my name, there was a brief pause on the other end of the line. Then she said, in a voice that was composed but not cold, "Elise, I've been expecting your call." That sentence nearly knocked me off my feet. "You have?" I said. "Your grandmother spoke about you often," she said. "And yes, I prepared a will for Dorothy Collins approximately 2 years ago. A comprehensive estate document. I still have a copy. I also have my notes from every meeting we had, and documentation of her intentions, prepared and signed in accordance with all legal requirements." My heart was beating so fast I could feel it in my throat. "There was a will reading today," I said. "A different attorney, a different document. It left almost everything to my uncle." Another pause, quieter this time, more careful. "I see," said Mrs. Osei. "Is that possible?" I asked. "Could she have changed it in those last months?" "It's possible," she said slowly. "A person has the right to update their estate documents at any time. However," she paused, "in this case, I have reason to believe the situation may be more complicated than a simple update." "What do you mean?" I asked. She hesitated for just a moment, and then she said something that changed the entire direction of everything that followed. "Elise," she said, "I need you to come to my office. There are things I need to show you in person. Things that are better discussed face to face." I was in my car within 10 minutes. Her office was small and warm and lined with bookshelves that reached the ceiling. There were framed certificates on one wall and a potted plant in the corner that had been there long enough to need a larger pot. She greeted me at the door herself, wearing reading glasses pushed up on her forehead and a quiet expression that I could not fully read. She sat me down across from her desk and folded her hands. "Before I show you what I have," she said, "I want to tell you something your grandmother said to me. She said it at our second meeting, after she learned that your uncle had begun asking questions about the will. She said, 'Patricia, I don't trust my son's intentions. I love him, but I don't trust his intentions. I want everything documented in a way that cannot be undone.'" She looked at me steadily. "So that is what I did." She opened a drawer and placed a thick folder on the desk between us. Inside was the original will, drafted and signed 2 years prior. It was exactly as Grandma had described: the house, the land, and the primary estate all designated to me. Gerald's separate bequest was there too, a sum of $80,000 from a secondary account. Then she placed a second document beside it, a typed record of every meeting she had held with Dorothy Collins, dated and detailed, every conversation documented. Then she placed a third item on the desk. It was a small digital recorder. "Your grandmother asked me to record our final meeting," Mrs. Osei said. "She came in 6 weeks before she passed, while she still had strength enough to drive herself. She sat in that chair where you're sitting now, and she told me that she was concerned her son was attempting to have a new will prepared under circumstances that might not reflect her true wishes. She said she wanted her voice on record, clearly stating her intentions, in case any dispute arose after she was gone." My hands were shaking. I pressed them flat on my knees. "She recorded a statement?" I said. Mrs. Osei nodded. 14 minutes, her voice, her words, her full legal name, and the date, her exact wishes, and her specific concern about what her son might do. She slid the recorder toward me. "Would you like to hear it?" I won't try to describe what it felt like to hear her voice again. Not yet. Not 6 days after I had stood at her graveside, not with my hands still shaking and my chest still raw. But I'll tell you what she said. She said her name, she said the date, she said it clearly and steadily and without hesitation. Then she said, I want it on record that my estate, as written in my will prepared by Mrs. Patricia Osei, reflects my true and complete wishes. I have not changed these wishes. I do not intend to change these wishes. Any document presented after this recording that claims to represent an updated version of my will should be examined with great scrutiny. She paused on the recording. I heard her take a breath. My granddaughter Elise raised herself in my house after her mother passed. She has been beside me every day. She has given up more for me than most people give for anyone in their whole lives. This property is hers. This land is hers. It was her mother's land too, and it belongs with her daughter. Another pause. If my son Gerald is contesting this, and I believe he will, I want people to know that I was not coerced into my original decisions. I was not confused. I was not pressured. I am a woman with a clear mind and a full understanding of what I own and who I want to have it. And I am saying it plainly, in my own voice, so that no one can claim otherwise. The recording ended. The office was completely silent. Mrs. Osei gave me a moment. She did not speak. She did not hand me a tissue or tell me it would be okay. She simply sat quietly and let me have whatever I needed to have. After a while, I straightened in the chair and looked at her. What does this mean? I asked. Legally, what does this mean? She laced her fingers together and looked at me carefully. It means, she said, that you have the foundation for a very strong legal challenge. You have a properly executed original will. You have documented evidence of your grandmother's intent. You have her recorded statement expressing specific concern about exactly the kind of document that was presented today. She paused. You also have the fact that the will presented at today's reading was prepared by an attorney your grandmother never consulted, at least not on record, during a period when she was in deteriorating health and under the care of the very person who benefits from that document. I let the weight of that settle over me. He forged it, I said. I'm not going to use that word yet, she said carefully. What I will say is that the timing, the circumstances, and the content of the new document are all deeply inconsistent with everything I know about your grandmother's wishes. And I think a probate court would find that inconsistency very interesting. She looked at me with those steady, careful eyes. Elise, I want to help you. Your grandmother asked me to document everything precisely because she anticipated this day might come. I believe I have a professional and moral obligation to stand behind the work she trusted me to do. She paused. If you want to pursue this, I will stand with you every step of the way. I had walked into that office feeling like I was at the bottom of the deepest hole I'd ever been in. I walked out with a folder under my arm and something completely different moving through me. It wasn't anger anymore, not exactly. It was focus. The weeks that followed were the hardest kind of hard. The kind where you're grieving and fighting at the same time, which means you never fully get to do either one properly. Every day had 2 layers to it. On the surface, I was handling Grandma's personal belongings, notifying people, writing thank you notes for the flowers. Underneath, I was in constant communication with Mrs. Osei and a probate litigation attorney she connected me to, a methodical, precise man named Mr. Dennis Farrow, who wore the same style of dark suit every day and spoke in sentences so carefully constructed they could have been used as evidence in themselves. Mr. Farrow reviewed everything within 48 hours of receiving the documents. He called me on a Thursday evening and said without preamble, "This is actionable. The question is how far you want to take it and how prepared you are for what it will cost, not just financially, but personally." I told him I was prepared. Your uncle has presented a will that was prepared and executed within the final 8 weeks of your grandmother's life, he said. During a period when she was on multiple medications, had reduced mobility, and had limited independent access to legal counsel. The attorney who prepared that document, Mr. Harlan, operates a firm that has been associated with 3 prior estate disputes in this county in the past 5 years. 2 of those disputes were settled out of court. 1 was dismissed. None of them resulted in a formal finding of wrongdoing, but the pattern is notable. What does that mean? I asked. It means Mr. Harlan is the kind of attorney you call when you need a document produced quickly and without too many questions, he said. It also means that the moment we file a challenge in probate court and those prior cases come to light, the judge is going to look very carefully at everything Mr. Harlan prepared on your uncle's behalf. He went on. He explained the legal framework, that to challenge a will on the grounds of undue influence, you need to show that the person making the changes was in a vulnerable state, that the person who benefits from the changes had a position of power over them, and that the changes themselves are inconsistent with prior clearly expressed wishes. We had evidence for all 3. What about the recording? I asked. There was a pause, a careful one. The recording, he said, is the most valuable single piece of evidence you have. It is your grandmother's own voice, in advance, predicting exactly this scenario and explicitly stating her intentions. In 20 years of estate litigation, I have never seen anything quite like it. It is not guaranteed to be definitive. Your uncle's attorneys will certainly challenge its admissibility. But if that recording gets in front of a judge, it will be very, very difficult for the other side to overcome. He paused again. Mrs. Osei was thorough, he said, and I heard something in his voice that was close to admiration. She prepared for this possibility in a way that most estate attorneys simply don't. Your grandmother was fortunate to have found her. I thought about that small card at the bottom of the box, the one I almost didn't look for. What do we do next? I asked. We file, he said simply. We file a formal challenge in probate court contesting the validity of the document presented at Monday's reading. We submit the original will and the supporting documentation as evidence of your grandmother's true intent, and we request an emergency hearing to prevent any transfer of property until the matter is resolved. How long will this take? I asked. Several months, likely. These cases move at the pace of the courts, but the emergency motion to freeze the property transfer can be filed this week, which means your uncle cannot sell or transfer anything until this is resolved. That mattered enormously, because I had noticed, in the days since the will reading, that Gerald had already made contact with a real estate development company about the land. He had been moving fast. Not fast enough. We filed on a Friday morning. By Friday afternoon, Gerald had been served with notice. He called me that same evening. The warmth was gone from his voice now, completely gone. Elise, he said, I don't know who's been putting ideas in your head, but this is a mistake. A serious mistake. You are going to spend money you don't have on a case you cannot win, and when it's over, whatever goodwill exists between us will be finished. I let him finish. Then I said quietly, Gerald, did you know that Grandma had Mrs. Osei record their final meeting? A pause, long enough that I counted the seconds. 5, 6, 7. I don't know what you're talking about, he said. His voice was careful now, very careful. She recorded herself, I said, in her own voice, her own words, telling Mrs. Osei exactly what she wanted to happen and exactly what she was afraid might happen afterward. I paused. She was very specific, Gerald. The silence on the other end of the phone was so complete it felt physical. Think carefully about what you want to do next, I said. And I hung up. When you file a probate challenge, the process that follows is not dramatic. It is slow and procedural and full of paperwork. But the thing about paperwork, when examined carefully by people who know what they're looking for, is that it tells a story. And the story that Mr. Farrow's team uncovered over the following 8 weeks was worse than I had imagined. Much worse. Mr. Harlan, the attorney who had prepared the new will, had been hired by Gerald approximately 5 months before Grandma passed, not 2 months. Not in those final rushed weeks. 5 months. Which meant that Gerald had been planning this before Grandma's health had declined to its final stage. He had found his attorney, established the relationship, and begun preparing the groundwork well in advance. The document itself, when submitted to a forensic document examiner hired by Mr. Farrow, raised questions. The examiner found that the signature on the new will, while resembling Dorothy Collins' handwriting, showed markers consistent with signature produced under physical distress, shakiness patterns, and pressure inconsistencies that differed from signatures on documents she had signed 1 year prior. The examiner was careful. She said she could not conclusively state the signature was forged, but she could state that it was inconsistent with the signature of a person whose handwriting she had examined across 23 other documents spanning 2 decades. Then there was the witness. Every will requires witnesses to the signing. The new will had 2. One was a notary employed by Mr. Harlan's firm. The other was a woman named Brenda Sayers, listed as a family friend of Dorothy Collins. Mr. Farrow's assistant tracked down Brenda Sayers. She was real. She had known Grandma casually from a church auxiliary group years earlier. But when she was contacted and asked about witnessing Dorothy Collins's will signing, she said something that made Mr. Farrow sit up very straight. She said she had signed a document at Gerald Collins' request, yes, but she said she was told she was signing a witness form for Grandma's medical care directive, not a will. She had not been present at any formal will signing. She had signed the form Gerald gave her at a family gathering, at a table in his kitchen, 4 months before Dot passed. She had never been told it was a will, and Grandma had not been present when she signed it. When Mr. Farrow called me to relay this, his voice had the specific quiet quality of a man who has just confirmed something significant. "Elise," he said, "the witness to your grandmother's will did not know she was witnessing a will. She was not present with your grandmother, and she signed under a misrepresentation of what the document was." I sat down slowly in my kitchen chair. I said. That's fraud," he said. "That's not a gray area. That's a direct, documentable misrepresentation that invalidates the witness attestation, and with it, the will's legal standing." I pressed my hand flat on the table. "Can she testify to that?" "She already agreed to," he said. "She is not happy. She liked your grandmother. She had no idea she was being used this way, and she wants to make it right." That was the moment I knew. Not hoped. Knew. Gerald's attorneys filed a response to our challenge 3 weeks later. It was aggressive. It attacked Mrs. Osie's documentation as incomplete. It questioned whether the original will had been prepared with proper diligence. It raised questions about my relationship with Grandma, and whether, as a non-blood relative, I had perhaps exercised inappropriate influence over an elderly woman. It even suggested, in carefully chosen language, that I had isolated Dorothy Collins from her son in her final years to position myself favorably in her estate. I read every page of it sitting at Mr. Farrow's conference table. When I finished, I looked up at him. "He's accusing me," I said, "of doing exactly what he did." Mr. Farrow nodded once. "It's a recognized legal strategy. When you cannot defend the truth of your position, you attempt to contaminate the moral landscape. Create enough doubt about everyone involved that the court is confused about who the actual wrongdoer is." He paused. "It doesn't work well when the other side has a recording." He allowed himself the smallest fraction of a smile. A man not given to showing much emotion, and even that tiny shift told me everything I needed to know about how he felt about our position. "We're ready," he said. "The hearing is in 6 weeks." In the weeks between filing and the hearing, something happened that I had not anticipated. The town found out. Small towns are like that. The moment a legal challenge involving a well-known family goes into court records, which are public, people begin to talk. And Gerald Collins was well known. He had been a respected businessman in that town for 30 years. He sat on the board of the local Chamber of Commerce. His name was on a plaque at the community center. People knew him. People liked him. Or people had liked the version of him they thought they knew. The woman from Grandma's church, Ruth, who had known Dot for 40 years, called me one afternoon. She had heard there was a dispute over the will. She had heard my name was involved. She wanted to know if what she was hearing was true. I told her as simply and as honestly as I could. She was quiet for a long moment. Then she said, "Elise, your grandmother talked about you constantly. She talked about you the way a mother talks about a child. She used to say, every time your name came up, she used to say, 'That girl is the best thing that ever came out of this family.'" I couldn't speak for a moment. "She would have wanted you to fight," Ruth said. "You fight." Over the following days, more calls came in. People from Grandma's church, from her neighborhood, from her garden club. They weren't calling to offer legal testimony. They were calling because they loved her, and because they wanted me to know that they saw what was happening. Some of them had things to say about Gerald's behavior in those final months, about his presence at Grandma's house, about certain conversations they had witnessed or overheard. Mr. Farrow spoke to several of them. 2 agreed to provide written statements. One of them, a woman who lived 3 doors down from Grandma's house, said that she had seen a man arrive at the house twice in the final 2 months, a man she did not recognize. He arrived in a car she did not know, stayed for approximately 30 to 45 minutes each time, and left with Gerald. She had made a note of it at the time because it had seemed strange. Grandma was very ill by then and was not receiving visitors other than family and home health aides. She had not known who the man was. Mr. Farrow cross-referenced the timeline. The man matched the description of Mr. Harlan. The attorney who prepared the new will had been at Grandma's house, not at his office, not in any formal documented setting, at her house, while she was ill, while Gerald was managing her care. That is not how legitimate estate planning visits are conducted. When this information was assembled into our evidence package, Mr. Farrow looked at it for a long time. Then he looked at me and said something I will never forget. "Gerald Collins made one very serious mistake," he said. "Just one?" I said, with the first faint trace of dark humor I had managed in months. He looked almost amused for just a fraction of a second. "The significant one," he said. "He underestimated the woman he was stealing from. Dorothy Collins was methodical. She prepared. She left a trail that she knew would matter. She didn't do it loudly. She did it quietly. She did it the right way." He paused. "That's who she was," he said. I nodded. "Yes," I said. "That's exactly who she was." The probate court hearing took place on a Thursday morning in November, 3.5 months after Grandma had passed. The courtroom was small and plain. Wood panels, fluorescent lights, a judge's bench that looked like it had been there since the building was constructed. It was nothing like the dramatic courtrooms you see in films. It was bureaucratic and a little tired-looking. But what happened inside it was not small. I sat at the plaintiff's table with Mr. Farrow. Gerald sat at the respondent's table with 2 attorneys from a firm in the city, the kind of polished, expensive attorneys you bring in when you need to project confidence and authority. They wore better suits than anyone else in the room. The judge was a woman in her 60s named the Honorable Margaret Blaine. She had a reputation, Mr. Farrow had told me, for being deeply attentive to elder estate cases. She had seen manipulation of vulnerable elderly people in her courtroom before, and she did not have patience for it. The hearing opened with procedural formalities. Both sides submitted their evidence packages. The judge reviewed them with care, making notes, asking specific questions of both attorneys. She was thorough in a way that reminded me, painfully, of Grandma herself. Mr. Farrow presented our case methodically. The original will, the documentation of Grandma's meetings with Mrs. Osei, the evidence of Gerald's early engagement with Mr. Harlan, the forensic examiner's report on the signature, the testimony of Brenda Sayers, submitted in a written affidavit, corroborated by a recorded phone interview, stating clearly that she had not known she was witnessing a will, had not been present with Dorothy Collins when she signed it, and had been misled about the nature of the document she was attesting to. Then he played the recording. The room was absolutely silent. Grandma's voice filled that small courtroom, clear and steady and utterly unmistakable. Her name, the date, her wishes, her concern, her specific fear, expressed in her own words, about what her son might do. I watched the judge's face while the recording played. Her expression did not change dramatically. She was a professional. But her pen stopped moving. She set it down on the bench in front of her and did not pick it up again until the recording finished. She looked at the recorder, and then she looked at Gerald Collins, and then she looked back at her papers. Gerald's lead attorney launched into a lengthy objection about the admissibility of the recording, questioning the circumstances of its creation, challenging its authentication. He was articulate and well-prepared, and his argument was technically thorough. Judge Blaine listened to all of it. Then she said in a voice that was entirely flat and entirely decisive, "The objection is noted and overruled. The recording was made voluntarily by the decedent, in the presence of her legal counsel, with full knowledge of its purpose, and authenticated by the attorney who was present. It is admitted." Gerald's attorney sat down. Then Brenda Sayers' affidavit was formally entered. Then the forensic signature analysis. Then the neighbor's statement about Mr. Harlan's visits to the house. Gerald's attorneys fought every piece. They were good at it, skilled, quick, technically precise. But there is a point in a legal proceeding where the weight of evidence stops being something you can argue around, where the pattern becomes so clear that technical objections start to sound like exactly what they are, noise designed to obscure something that is already in plain sight. Judge Blaine reached that point clearly and efficiently. She recessed for 40 minutes to review the full evidence record in her chambers. When she came back, she sat down, put on her reading glasses, and looked at both tables with an expression that contained no ambiguity whatsoever. She said, "I have reviewed the evidence presented by both parties in this matter. I find the following." She found that the original will, prepared and executed by Mrs. Patricia Osei on behalf of Dorothy May Collins, was legally sound in its preparation and reflected the decedent's clearly documented intentions. She found that the subsequent document, prepared by Mr. Harlan and presented at the will reading, had been executed under circumstances inconsistent with sound estate practice, specifically noting the absence of properly obtained witness attestation. She found that the testimony of Brenda Sayers constituted direct evidence of misrepresentation in the procurement of a witness signature, which she stated, in precise legal language, rendered the attestation invalid and the will unenforceable. She found that the recording made by Dorothy Collins, in conjunction with the supporting documentation, constituted compelling evidence of the decedent's true intent. She declared the document presented at the will reading null and void. She reinstated the original will as the binding estate document of Dorothy May Collins, and she ordered that the estate, including the house, the land, and all primary assets, be transferred to Elise Marie Collins, as specified in the valid will, within 90 days. She also referred the matter of the fraudulent witness procurement to the County District Attorney's Office for review. Then she looked up from her papers and over her glasses at the respondent's table, and she said, in a tone that was perfectly measured, but carried the full weight of everything she had heard that morning, "This court takes seriously its responsibility to protect the wishes of those who are no longer here to speak for themselves. The record reflects that Dorothy Collins did speak for herself, clearly, and in advance. This court listened." She gathered her papers. "We're adjourned." I sat in my chair for a long moment after the judge left. Mr. Farrow placed a hand briefly on my shoulder, a professional gesture, restrained, but I felt what was in it. He was not a man who showed satisfaction easily, but he showed it then. Gerald and his attorneys left quickly, without looking at me. Sandra walked out with her eyes fixed forward, her heels clicking sharply on the floor, in a rhythm that said everything about what she was feeling, and none of it was remorse. I didn't watch them leave. I was looking at the recorder sitting on the evidence table. the small, plain, ordinary device that an ordinary woman with extraordinary foresight had used to do something that changed everything. Mrs. Osei had waited outside the courtroom. She didn't attend the hearing itself. Her work had been done long before, in the documents she'd prepared and the recordings she'd made. But she was there when I came out, and when I saw her standing in the hallway in her neat coat and her reading glasses pushed up on her forehead, I did something I had promised myself I would hold together for. I cried. She put her arms around me and she said nothing. Not, "It's okay." Not, "I told you so." Not, "Your grandmother would be proud." She just stood there quietly while I had the moment I needed, in the hallway of a courthouse that smelled like fluorescent lights and old carpet, with the November light coming in gray and thin through the windows. After a while, she said softly, "She knew what she was doing, Elise. She knew exactly what she was doing." "She always did," I said. The 90 days that followed were procedural, but they were also real. The property transfer was processed. The development company that Gerald had been in contact with sent a letter acknowledging that their discussions had been with a party who had not had legal authority to negotiate the sale. The matter went no further on that front. Mr. Harlan's relationship with the district attorney's office became a matter of public record. I was not involved in what followed. That was the county's business, not mine. But I know that Brenda Sayers' account was taken seriously. I know that the pattern Mr. Farrow had identified, those 3 prior estate disputes, was also now part of the conversation. Gerald called me once, in the weeks after the ruling. He didn't apologize. I hadn't expected him to. He said, in a tired voice that sounded for the first time like a man who was actually old, that he hoped this didn't have to mean that there was nothing left between us. I thought about that for a moment. "Gerald," I said, "there has never been anything between us that you valued above your own interests. Not once in my life. And you tried to take from me the only person who was ever truly on my side." I paused. "I don't have any hatred for you, but I don't have any hope for us either. And I'd like you to respect that." He didn't argue. He didn't apologize. He said, "Okay," and hung up. That was the last time we spoke. I moved into the house on a Saturday in early February. It was cold. The pear tree in the backyard was bare-branched and still, the way winter trees are, just waiting. I stood on the wide porch for a long time before I went inside, with my hands in my jacket pockets and my breath making small clouds in the cold air. The house was exactly as Grandma had left it. The furniture, the smell of the kitchen, the way the afternoon light came through the front window at a specific angle and fell across the living room floor in a way I had known since I was 9 years old. I walked through every room slowly, without turning on the lights yet, just letting my eyes adjust to the winter afternoon coming in through the windows. In the kitchen, I stood at the table where she had poured 2 cups of tea and told me to remember the truth no matter what. I put my hand flat on the table surface. "I remembered," I said quietly, to no one, to her. "I remembered, Grandma. I know what you're probably wondering." The land was worth somewhere between $600,000 and $800,000. Did I sell it? Did I take the money and move on? No. I'm not going to pretend that the idea didn't cross my mind. I had student loans I was still paying off. I had a car with a check engine light that had been on for 6 months. I had watched my bank account carefully for years, measuring every purchase, every bill, every unexpected cost that life throws at you when you're doing it alone. The money would have changed everything, practically speaking. But I kept thinking about what Grandma had said at that kitchen table, about how this was my mother's land, about how it was my foundation. You don't sell a foundation. Instead, I did something that felt, when I first thought of it, almost too small for the size of the moment. But the more I sat with it, the more right it felt. I converted one portion of the land into a community garden. The town had been trying to establish one for years without finding the right location. The land next to Grandma's property, a flat, south-facing section that caught maximum light, was perfect for it. I worked with the town council to establish a formal arrangement. The land remained mine, but it was available to the community, managed by a volunteer board, free to use for families who wanted to grow their own produce. Ruth from Grandma's church cried when I told her. She said Dot had talked for years about wanting to do something like that with the land, but had never quite gotten around to it. I named it Dorothy's Garden. The pear tree in the backyard bloomed that spring. White flowers first, and then, as spring deepened, small green buds that would become fruit by autumn. I sat on the porch some evenings and watched the tree and thought about cycles, about how things that seem fully over sometimes aren't, about how what you plant, if you tend it with enough care and patience, does not simply disappear when winter comes. It waits. I've had a lot of time to think about this story, about every piece of it. I think about Gerald sometimes, not with bitterness, at least, not the way it used to feel, sharp and hot. It's more complicated than that now. Gerald is a man who spent his whole life in proximity to something he thought should have been his, watching it go to other people, watching his mother pour her love into a child who was not blood, and somewhere along the way deciding that the answer to that frustration was to take rather than to earn. I don't excuse what he did. I don't minimize it. What he did was wrong in a way that the courts confirmed and that history will record. But I understand the poison of it. The way certain feelings, if they're never examined, if they're never brought into the light and questioned, will grow quietly in the dark until they become something that hurts everyone, including the person who's carrying them. I think about Mrs. Osei constantly, about what she did, which was technically simple. She documented her client's wishes thoroughly. She recorded a meeting at her client's specific request. She kept her files organized and complete. That is what she was supposed to do. That is the job. But here is what I've come to understand. Doing the job the right way, completely and carefully and without cutting corners, is actually rare. Most people do enough. Most people do what's required and stop there. Mrs. Osei did more than what was required, not because she knew it would matter, but because that is the kind of professional she is. That is the kind of person she is. Grandma found her because she was looking for someone exactly like that, and she found her through a church event, on a small white card. That is not luck. That is attention. That is what it looks like when a person pays close attention to what they need and goes and finds it instead of settling. I think about Grandma most of all. I think about the woman who raised me without ever once making me feel like a burden or a second choice or a responsibility she had accepted reluctantly. The woman who poured 2 cups of tea and told me to remember the truth no matter what happened. The woman who sat in Patricia Osei's office 6 weeks before she died, 6 weeks when every movement cost her effort, when she must have been exhausted, and spoke 14 minutes of quiet, careful, deliberate truth into a recorder so that the people who loved her could not be robbed without a fight. She couldn't come to that courtroom, but she was there. Every piece of paper, every dated note, every word on that recording, that was her, working on my behalf from beyond a place where anyone could reach her. That is love. Not the easy kind, not the comfortable kind, the kind that makes plans, the kind that thinks ahead, the kind that says, I cannot control everything, but I can prepare. I can document. I can speak clearly while I still have the voice to do it. The kind of love that fights for you even when it's gone. There are things I would say to you if you are sitting somewhere in a version of the situation I was in. If you are watching someone you love age and you can feel the circling beginning, family members who are suddenly more attentive, more present, more interested in conversations they never cared about before. Pay attention. Not with paranoia, not with suspicion of everyone, but with clarity. Talk to the person you love while you still can. Have the real conversation, the one about what they want and what they're afraid of and what they need documented. It is not morbid. It is responsible. It is one of the most loving things you can do. Find the right professional, a thorough one, the kind who does more than the minimum, who keeps records because records matter, who treats your family's history like it is worth preserving carefully. Those people exist. They are worth finding. And if someone tries to tell you that a person you knew deeply, a person who loved you clearly and specifically, suddenly changed their wishes right at the end, right at the moment they were most vulnerable and least able to advocate for themselves, don't accept it quietly. Ask for documentation. Ask for proof. Ask for the original. Ask all the questions. Make them uncomfortable with your questions if you have to. You are not being difficult. You are being faithful. You are doing exactly what the person who loved you would want you to do. The pear tree is heavy with fruit this year. I pick some of it myself, and the rest I leave for whoever wants it. The neighbors know they can come through the backyard gate. A few of the kids from the community garden come by on weekends, and I send them home with bags of pears and sometimes cookies if I've had time to bake. Grandma's shoebox of letters is on the shelf in my bedroom. I've read all of them. Someday I want to do something with them. I'm not sure what yet. Maybe nothing more than keeping them exactly where they are, safe and intact, the way she kept them. Her handwriting is on some of the envelopes, precise and slanted just a little to the right, the way it was on everything she ever wrote me. Birthday cards, notes in my lunchbox when I was small, the card she slipped under my dorm room door the week I started university, that I still have folded in my wallet. She was a woman who put things in writing because she understood, better than most people ever do, that words said aloud are gone the moment they leave your mouth. Words on paper stay, and the right words, kept in the right place, by the right people, they can change everything.